forms of contract. Ano ba yung mga forms ng contract? Di ba nasabi natin kanina that contracts are consensual. Ibig sabihin, the mere giving of consent is enough to is enough to form a contract. Gaya ng sabi dito sa general rule, contract shall be obligatory in whatever form they may have they may have been entered into provided all essential requisites are present. Basta present si COC, merong consent, merong object, merong consideration, and they agreed. Yan nga, dahil nga may consent, the contracts must be obligatory kahit ano pa ang form niyan. Okay? Of course, there are exceptions. May mga exceptions tayo. The exceptions are when the law requires that it be proven in a certain way or that it be made in some form for validity or enforceability. So may mga types ng contracts na hindi siya magiging valid or hindi siya magiging enforceable kapag kapag wala siyang specific form. Okay? First, there are contracts which are supposed to be in writing or nakasulat kahit nakasulat siya for it to be valid. Okay? So first, donation of real property. Donation of real property must be in writing. Kailangan nakasulat siya, the donation and the acceptance and acceptance kasi naalala niyo, 'di ba? Nung last time na na-discuss natin yung donation, yung in the context of donation, kailangan may acceptance. So kapag nag-donate ng real property, the acceptance must be in writing. In fact, it must be in a public instrument. By public instrument, we mean that it is notarized. That it is notarized para it's as if it's a notice sa lahat ng tao that donation happened and the acceptance also happened. So, yun. Donation of real property, kailangan nakasulat siya, and in fact, it must be in public instrument. Okay? Donation of personal property exceeding 5,000. Kapag mag-donate ka ng isang bagay ng more than 5,000, it must be in writing. Kailangan nakasulat siya. Pero not necessarily in public instrument. Okay? So, pwede na nakaano lang, na handwritten or encoded, pirmahan, mga ganyan. Ito, sale of land through agent. Ito naman, kung gagamit ka ng agent sa pagbebenta ng lupa, it must also be in writing. The same with pagbebenta mismo ng lupa. But in that case, na siya, public instrument ang kailangan. Okay? Stipulation to charge interest. Okay. Ito hindi pwedeng mag-set ng interest ng hindi nakasulat. So, kailangan nakasulat siya para maging valid yung pag-charge ng interest. Otherwise, kung hindi valid dahil hindi nakasulat, pwedeng it may be reduced to the legal rate. Depende sa court. And chattel mortgages. So, itong chattel mortgages, kunwari, sinangla mo yung yung sasakyan or cellphone, mga ganyan, kailangan may kasama siyang affidavit of good faith. So, this must be in writing as well. Itong chattel mortgage. So, yun. That's one. So, itong mga klaseng contracts, although this is not the complete list, you can just look it out sa provisions ng law. So, itong mga klase ng contract na to need to be in writing para maging valid sila. Okay, another exception is in a public instrument to be effective against third persons. There are certain contracts that need to be in writing para maging effective siya as opposed to other persons. Like contracts involving real rights, like pagbebenta ng lupa, pag-relinquish ng lupa, pag-donate ng lupa, mga ganun. Or pag-donate ng buildings, pagbenta ng buildings, mga ganyan. Since these are real rights, they involve real rights, they must be in public document. Kailangan naka-notarized document sila. Okay. Or renunciation of hereditary or CPG rights. Ano itong hereditary rights? Yung mana mo sa lupa, kapag mag-waive ka ng pag quit claim, ito yung tinatawag na quit claim. Kapag nag-quit claim ka ng ano mo, ng claim mo sa isang sa ano sa prop sa ano sa mana, it needs to be in public document para maging effective as against third persons. And CPG rights, yung karapatan mo sa conjugal partnership of gains. If you married under the yung conjugal partnership of gains, you need to renounce kung ayaw mo kung ayaw mong kunin yung properties mo doon at i-renounce mo siya, you can do so in a public instrument para maging valid, para maging effective siya sa third persons. And all other contracts exceeding 500 pesos in amount, para yung ano nyo, yung contracts nyo na with the value exceeding 500 in amount, kailangan nakanotaryo siya para maging effective against third persons. Pero it's effective kahit naman private instrument. Kaya lang, the effectivity is only limited sa inyong dalawang parties, not really as against other persons. And finally, there are types of contracts which are supposed to be in writing to be enforceable. Uh, Example of this are yung contracts covered by the statute of frauds. Now, itong statute of frauds are sets of, this is a provision of law na nagsasabi na something needs to be in writing, para to protect the rights of the debtor and the creditor. Naka-enumerate ito sa batas, but unfortunately, we don't have enough time to enumerate this. But siguro kung mayroon tayong time later sa integration, we will discuss this. So yun yung mga matters relating to sa forms ng contracts. Again, as a general rule, hindi kailang a contract is valid basta meron yung COC. Exceptions ito mga ito. Kumbaga, may mga special requirements sila kasi usually these are very important, these are more important relationships or more important contracts that na kailangan mo ng evidence. So kaya mo siya pinapanotarize or kaya mo siya sinusulat in writing, no?